proceedings. While it enhanced transparency, there have been concerns regarding the misuse of content and trolling of judges' remarks on social media. So, ma'am, I want to know the safeguards or reform do you think that is necessary to ensure that online streaming contributes positively without leading to misinterpretation of undue criticism of the judiciary? For example, you have handled the Patanjali case. Also, I want to know about the laws being played by AI in judiciary.
So, this is a multi-pronged question. The first thing would be the role of AI in expediting matters that are pending in court. We all went through the COVID-19 phase, and we had reached a stage where everything was shut down. And for a few days, and just for a few days, the courts had also to shut down. But it was at that time that the fact that one could do virtual court gained a lot of impetus. In Delhi High Court, initially, when AI was introduced and PDF files, paperless courts were introduced, they were confined to only matters relating to taxation and arbitration. We hadn't expanded it to all jurisdictions. But when COVID hit us, we had no choice but to function in every jurisdiction virtually. The biggest advantage was that the doors of the court were kept wide open during peak pandemic when everything was shut down and the country was in a lockdown status. I think India was one of the few jurisdictions where courts continued to function through such a tough phase. And that was all credit to the staff, to the registry. That was the backbone of the judges who were working overnight just to ensure that we got the files which were coming to us physically to be able to go through it in the night, and such of the matters that were urgent to address the issues the very next day. So though the number of cases were fewer at that time, but the urgent cases were being listed without exception. There was a procedure where a request could go online by the lawyers to the registrar. Registrar would sift the matters and check the urgency, run it through the Chief Justice and list them. So that process was something which helped the judiciary a whole lot. And the fact that a litigant could sit at home and see the proceedings that were happening in court was a big thing at that point in time. So as far as AI is concerned, I think that it had a very positive role to play for us. Another aspect was that as we got used to PDF files, virtual appearances, hybrid modes also came in later on. Some people who couldn't have come to the court physically could log in and see the proceedings. Some lawyers who had difficulties could stay at home and any part of the country and log in. It worked wonderfully for women litigants and women lawyers too, because women have to multitask. And women lawyers had a home to run, had to do so many things, take care of their parents, being the primary caretakers for their children. They need not have come to court or their office. They could work from home, attend to their case and maybe go back to some work, attend to another case in another court. So for those target persons, this worked beautifully. As far as the negative impact of this is concerned, as you pointed out, that there is a lot of trolling of judges. Well, I guess that we have to take the bad with the good, and looking at the good, which is more predominant than the bad, perhaps accept it as part of the system and go on. Speaking for myself, I've not been on social media ever since I got appointed as a judge. So really one is, in a manner of speaking, insulated. One doesn't know what is happening around you. In that sense, if you don't know, it's better for you. You are more free in your mind to say and do what you think is right in a matter. So I think we'll have to accept it and get on with it.
Since you are one of the prominent female figures in the judiciary, so what is your perspectives on the representation of women in the legal field, and what initiative would you suggest to encourage more gender diversity?
Okay. The first and the foremost thing is that women, for a long number of years, at least in the first half of the last century, there were very few of them. Even up to 90s, I would say that the number of women practitioners were very few. They found it difficult to be able to make a go in their career, And that was not attributable to them alone, but their circumstances. Many of them who came into the legal profession had to get married and move on. Some of them had to take breaks in their career because they had to procreate. Then children came along. They had to spend time with the children. So those long breaks in career took place, due to which they were disadvantaged. Such of their contemporaries with whom they had started their career by then had gone much higher, had achieved much more. So they had that disadvantage, for which they can't be blamed. Those of them who came back many times were such of the women lawyers who had a backup within the family network, as in their work was being attended to either by their husbands or their father, brother, or any family member. So the clients were retained. Invariably, for anybody who drops out of a practice suddenly, the clients have no option but to move on to another lawyer. So that retention of a client can't take place for a woman. That was one of the big negatives, and continues to remain so. Many times the women, they get married, they have to relocate from the city they are practicing in. They have to go to any part of the country or abroad. Then what happens to their career? They sacrifice their career for the sake of the family, for the sake of their married life, and all of that. So these are considerations which did cause an impact in the presence of women in this field. Now, I think from 2000 onwards, one is seeing a lot of serious women practitioners who would like to push the marriage to a bit later, to be able to make a name for themselves in their career, or work harder and then marry. There's also been a trend among many of the youngsters to marry a bit late and establish themselves before they look at marrying at all. So that in a way has worked for women practitioners who are willing to work harder, work longer hours, and work shoulder to shoulder with their male colleagues to be able to deliver their expectations of their clients. And as far as women in the judiciary are concerned, because the pool of the women is lesser from among the lawyers, then naturally the pool of choice is lesser for the collegiums of all state high courts to select the women. And still there is an effort to look out for good women and look out for domain specialists, which has been happening in the recent past, and get them on board, whether it is tax, whether it is criminal, whether it is IPR, such like. That is also something which is important. So those women get that opportunity to be able to get elevated purely on the basis of their merit.
So I want to know your personal view on, since separate toilets for women is a basic necessity, we all know. But there is a number of washrooms for women are far less in comparison to the number of washrooms for males in court complexes. What do you want to say on this?
So this is such a basic issue, toilets. The first thing anybody wants is a comfort in a working place. I do remember that when I had joined practice in the Delhi High Court, there were very few of us. For the women practitioners who would go to court, there was just one toilet in a women's bar room, which was on the second floor of what is now known as the old block, at the far corner of the building. So if one really was desperate to use the toilet, one had to make sure that you moved out maybe 10 minutes before wherever you were to access that single toilet. It was that difficult. On every floor, there were toilets for men, but that was not the case when it came to women. Subsequently, after a lot of debate and discussion and request to the High Court, the High Court allocated a ladies' bar room on the ground floor to women, which was by partitioning the common bar room. And that's when toilets were actually carved out in the main block for women to use. It was a big challenge. In High Court, if the situation was like that, you can imagine what it was in the district courts earlier, with only at that point of time 2 district courts, Tisazari and Patiala House. Situation was very difficult. Women found it impossible to practice. Where would they go if they wanted to use a basic necessity of life, a toilet? It was a big challenge. We've also had occasions when women judicial officers in some remote places did not have the facility of a toilet and had to control themselves, manage themselves, wait for an opportunity to go to where? To the bar room side to use the toilet, and how difficult it must be for a woman judge to do that. So these were challenges that most women have faced and very few want to talk about.
So, ma'am, I want to know your view on judge population ratio, because in a population of we know we have a population of 139.23 crore, and there is a patency of 5.05 crore cases, 100% by 20,000 judges working all levels of judiciary. What do you want to say on this?
So ours is a country which is booming in population. On a rough and ready scale, it's a judge population ratio is 1 judge to perhaps 20 lakh population, which, as you said, from the district court up to the Supreme Court. So the volumes is a big challenge. The amount of litigation that is being spewed, it becomes a struggle for the courts to handle it. It's not just the fact that there should be more judges, there should also be some thought about the new statutes that are introduced by the legislature. The impact of those statutes on the litigation and the expansion of litigation is direct. So sometimes if some issues are addressed by the judiciary having a role to play in explaining or its difficulties, or a participative role limited to how the impact of a particular legislation will be on the courts, it would help. Take for example a random legislation like Negotiable Instruments Act. It has spewed so much of litigation across the country. Courts are chock-a-block full in the districts, respective districts, particularly districts which are commercial districts or where there are financial districts. They are inundated with matters because every other institution on check bouncing, and particularly when these are cases of loans, cars, EMIs of such sorts, the litigation is humongous. So the courts are inundated, and then when people complain of long dates, what does that judicial officer do? He has little choice. He has to manage a board, he or she or whoever it is. That is where the challenge is. So if there would be some kind of a balance, perhaps it would help. In particular jurisdictions, we need more judges. When we need more judges, then besides the judge, we need a whole paraphernalia, which includes the courtrooms, the supporting staff, and all of it. So it's easy to say increase the number of judges. In Delhi, we had reached a stage, and currently, where young judicial officers have no courtrooms to go to. So though they are being trained, they have no place where they can hold court. How difficult is that? How will they be able to dispense justice? They can't be in district court sitting in division benches. There's no such concept of division benches. So we are having to make alternate arrangements in the High Court for them to ensure that perhaps sometimes their trainings are increased so that they get more hands-on experience. Sometimes they're assigned other kind of work so that in the meantime the courts come up. You know for a fact that Honorable the Chief Justice of India recently had to pass orders in the case of Delhi to ensure that the government gives land, gives space for courtrooms to come up. That is how the challenge is, and it is fairly difficult.
Ma'am, I want to know what advice would you give to young lawyers aspiring to become judges, especially in terms of maintaining integrity and dedication throughout their careers?
So young lawyers who aspire to become judges should perhaps think of first aspiring to become good lawyers who have a good practice, who are honest, and who do their work honestly for the sake of the client. If somebody is good in his career, in his work, in her performance, in her approach to matters, it is bound to give that person a good, well-rounded character, and it's a natural progression that courts will themselves look at those particular lawyers who are bright to pick them up. So if instead of aspiring to be a judge, if the young lawyer would aspire to be a good lawyer, a lawyer whose performance matters, who is respected by the court can rely on her when she argues, that confidence building itself is a way forward for a person to be perhaps ultimately come in that zone of consideration for appointment. And what's true for women is equally true for young men. Both of them have to do that to make a mark in their career. Honesty, sincerity, integrity, and hard work do not have any substitutes.
Ma'am, I want to know do you like to share some thoughts on a particular case or judgment that you feel had a significant impact on society during your tenure?
So, one of the judgments that had an impact on the society, off the cuff, I can think of the case of Aureliano Fernandez versus University of Goa, State of Goa, I think it was, which was delivered sometime in March of last year. That was to do with the prevention of sexual harassment at the workplace. The nuances of a matter was a disciplinary proceeding that was conducted against the accused, the person against whom the allegations of sexual harassment were leveled. And there were a lot of loopholes that we found in the process that was adopted by the disciplining authority to impose a punishment on that particular person. But it went beyond that. When we discovered that these kind of fallacies in the process of the disciplinary proceedings can take place several times, it did occur to us as a bench, and at that time Justice Bopanna and I were sitting on the bench when this matter was taken up. And it was thought appropriate to expand the scope of that petition and remind ourselves that Vishaka had happened several years ago. And it was going to be a decade of, we were going to celebrate a decade of the Act, but nothing on ground really to show for itself. And we felt that several agencies had committed a lot of lapses in constituting the Internal Complaints Committee, which we call now ICs, in making sure that they were in place, in their compositions, in spreading the word amongst the employees of how important this statute was, in letting people know that there was something like a committee to which the complainant could go. And the role was of all kind of state actors, which included the government, the state governments, the central government, the ministries concerned, the concerned departments in each state, and all of those organizations, in fact, to my mind, equally the private sectors, who had to wake up to the fact that there was this act. It needed implementation. It needed protection of women who were who were suffering for sexual harassment at the workplace, and the women themselves had to feel strong and bold enough to approach the internal committee with a complaint. So those confidence building measures were also important. We also felt that the judiciary needed to be more conscious and cognizant of it. So all the state judicial academies were also requested to do an exercise to spread the word and hold workshops to spread the message of this particular enactment and its benefits.
There is a judgment where you and Justice Vivira has given us different views on the abortion laws.
Yes.
I want to know about this.
So there was a matter that was marked to our bench. Justice Nagratna and I were sitting together in a matter which related to a lady who had come at a very late stage. 24 weeks is the cutoff under the Act for any such abortion, and it could be for various reasons. It could be on account of the fact that it was pregnancy that was foisted with danger for the mother. Maybe the life of the mother was in danger. Or there could be circumstances where the child could be suffering from some kind of deformities, which would lead to which could lead to complications at a later stage if the baby was born. It could be cases of a case of rape, or somebody who was mentally retarded and not in a position to know that she was pregnant or at the right time. So there are several circumstances that the statute considers. But the case that came to us was of a lady who already had 2 sons. She was married. She was staying with her husband, with her mother-in-law.